My name is Jennifer Dutzman-Coy. I'm an attorney for Nine Associates. I specialize in Social Security disability. There are two types of Social Security disability. One is Social Security disability benefits, which are based on your past work and what you used to do, the earnings that you've reported to Social Security. The other type is supplemental Social Security income, which is based on your income and resources. Okay, to know whether you qualify for Social Security disability or supplemental security income, the basic question is whether you have worked for 5 years out of the last 10 years. And if you have, you qualify for Social Security disability. If you haven't, then you could probably still qualify for supplemental security income. To apply for either Social Security disability or supplemental security income, SSI, what you do is you go to your local Social Security office and submit an application. You do not need an attorney to apply for Social Security benefits. After you have gone to your local Social Security office and applied for benefits, many times a person will be denied even if they have a legitimate disability claim. If you are denied, at that point you can contact an attorney. If you contact me after you've been denied for Social Security disability benefits, I will file an appeal on your behalf and we will attend a hearing with an administrative law judge. Social Security uses a 5-step process. The first step is whether you are working. You can work if you're making less than $1,000 per month. If you're making more than that, you do not qualify for Social Security disability benefits regardless of whether you are disabled or not. Social Security won't consider whether you are physically or mentally disabled even if you really are, if you're working over $1,000 a month. Second step in the disability process is whether you have a medically determinable impairment. Social Security will consider all of your medical records and they will make a determination as to whether you have a severe impairment under their rules. If you do, they will look at their records at the third step and see if you meet one of their qualifications to be automatically disabled because of your medical impairment. This third step is called the listing of impairments step. Social Security has a list of different impairments of certain severity, and if you meet those, like I said, you will be automatically qualified for disability and you will get your benefits after that. A listing is a specific statement of what an impairment is that will qualify you for disability automatically. A moment ago I mentioned the listings. These 2 volumes are the listings. These are comprised of thousands of pages. Scoliosis may qualify you. If you have a heart condition, you may qualify automatically under the listing. Spinal stenosis may also qualify you if you have any of those. If you don't meet a listing at step 3, the process goes on. You go on to step 4. And Social Security will look at your past work, what you used to do, and they will check to see what your limitations are with your medical condition. If your limitations prevent you from being able to do your past work, then you meet that step and the process goes on to the 5th step, which is to see if you can do any other work in the economy. This doesn't mean that there's a job that exists out there for you, but it does mean that there's something that you could potentially do. And this is based on your limitations that are in your medical records based on your condition. At step 5, in determining whether you can do other work in the national economy, what you would need is a statement from your doctor saying what your physical limitations are, and that is something that we would seek for you. Social Security calls this your residual functional capacity assessment. This is what you can still do despite your limitations. physically or mentally. And this is based on the evidence that your doctor has of treating you in the past. What our office would do for you is we would obtain all of your medical records and look through them and first see, as I was discussing before, to see if you met any listings at step 3 to get you automatically qualified for disability. We would also seek a statement from your doctor about what your limitations are. We would write you an extensive brief to the administrative law judge stating exactly why you meet the disability requirements and why you should be found disabled. Remember that you are your own best advocate. If Social Security denies your claim, keep fighting. You can win. A lot of the time Social Security will deny people just for the sake of denying people. If you keep going very often, you can win. There are several other ways that you can automatically qualify for disability, and if you'd like to hear about those, please contact our office. Our website is www.mylaw.org.